Supreme Court's July 11, 2024 judgment includes far-reaching decisions that will significantly alter local government administration in the country. The Supreme Court has affirmed the financial autonomy of Nigeria's 774 local governments. In the unanimous judgment of its 7-member panel on July 11, the Supreme Court unanimously upheld the suit brought before it by the federal government to strengthen the independence of local governments in the country. A member of the panel, Justice Emmanuel Agim, who delivered the court's lead judgment, held that the local governments across the country should, from July 11, receive their allocations directly from the Accountant General of the Federation. He ruled that it is illegal and unconstitutional for governors to receive and uphold funds allocated to local government areas in their states. He ordered immediate enforcement and compliance with the orders of the court by state governments and successive governments henceforth. Today we'll be discussing an important part of this judgment, and that is the local government tenure elongation by the Supreme Court. The judgment partly reads: under Section 135, subsection 3 of the Constitution, the tenure of 4 years for the President, provided for by Section 135, subsection 2 thereof, shall be extended for periods not exceeding a period of 6 months at any time by a resolution of the National Assembly if it is not practicable to hold elections. By the same token, by a law of a State House of Assembly, the tenure of local government councils can be legally extended for any reason, such as insecurity or war, if it becomes impracticable or impossible for elections into the local government councils to be conducted. The mandate given to an elected local government council is the mandate of the electorate of that local government area. And if the tenure is extended, it is the people's mandate that is extended. If the tenure of a local government council is truncated, as it is the norm now, it is an illegal termination of the electorate's mandate, and it is not to be encouraged but roundly condemned. Joining me on Open Conversation again is Victor Eniche, a social political analyst. Good morning, Victor, and welcome to Open Conversation.
Good morning, Larisha. It's always good to be here.
Thank you. It's always a pleasure having you, by the way. Now, Victor, what is your take on this Supreme Court judgment on local government tenure elongation? You know, when this Supreme Court judgment, when the judgment came out, a lot of media houses, people focused mainly on the financial autonomy and also on the separation of powers. But nobody is talking about this very sensitive aspect, and that has to do with, you know, the tenure elongation of local government chairmen. What do you have to say to this?
I don't think people are not talking about it. First of all, I think the issue was prior to the release of the CTC, of the judgment, a lot of details were skeptical.
Yes.
People were not sure of the details of the judgment. So, you know, having released the CTC of that judgment, it enabled people to properly scrutinize what judgment was, and of course the order that came with the judgment, which is implementing the credit of the judgment immediately.
Yes.
You know, I think it's just the mischief of politicians to ignore certain things, you know, certain part of the law when it doesn't favor them. I think that's just what is happening.
Playing out.
What should happen is, you know, laws when implemented or when made should be implemented. There are agencies of government that is saddled with responsibility of, you know, executing laws, you know, as made by the legislation and, you know, interpreted by the courts as it is right now with the Supreme Court. So for me, I think it is the mischief of politicians and the failure of agents of government to implement certain policies. For instance, if the court has declared, the highest court of the land, you know, I must point, has declared that it is illegal to have caretaker committee chairmen, you know, take over local government affairs. If the court has said it is illegal for you to, you know, of course, although that part is the River State case is that they were not Okay, no, they were, because their tenure was elongated by the State
tenure of the outgone River State Council chairman.
Yes,
it was elongated by
the State House.
Yes, of Assembly.
Then, So for me, I think it behoves on the other arms of government that is saddled with responsibility to implement these laws. If someone comes and says his caretaker committee of River State, and the law has said there's nothing like that, it is not recognizable, it is illegal, I think the police, for instance, as one aspect, should not recognize such individuals, because by law it is said that it is illegal and you're not meant to be there. But I remember some weeks ago we had an argument that I think that was propagated by, is it Sheyi Makinde of Oyo State, when he talked about the judgment giving 90 days space for the caretakers to be there and for elections to be conducted. I think the release of this document, has trashed that idea that was pushed by
the judgment was
governor.
That it should be implemented with immediate effect. Yes.
So, but the argument then back and forth, what happens then? Should there be anarchy? Of course, nature, like they say, abhors a vacuum. So what is to be done in those cases? That is the argument where we are. But one thing that we must emphasize on is the directions or directives of the judgment, which said with immediate effect.
Immediate effect.
Now, for the case of River State,
Well, we'll still get to the case of River State, but let me hear from Barrister Ndamzi. Barrister Ndamzi, you're a legal practitioner. What is your take on this matter?
Yes, the Supreme Court, what the Supreme Court did is interpreting that section of the Constitution that allows the president tenure elongation should, in case it becomes practically impossible to hold elections. So the court went ahead to tailor it down and also said that such token, applies to the local government areas in Nigeria. So it's a matter of interpretation, and the Supreme Court have, opened our eyes as to what that section of the law have said. And just like my brother Victor here posited, that those saddled with responsibility of enforcing these laws, in fact, in my own opinion, I think they are weak. They are weak in performing their duties as enshrined by the police.
Who should enforce it?
The police. The Police Act empowers the police to maintain law and order in our society. So if the highest court in the land have given a directive, I think it behooves on the police authority to move in and enforce it. But also, another thing is there is also lack of political will from the leadership of the country to allow some of these things happen according to our rules and set laws. Because I remember the time of Yaradua, when the Supreme Court ordered that Rotimi Amechi should be sworn in immediately as the governor of the state. I remember Yaradua made a statement and authorized the IG to move in immediately, making sure that that decision of the Supreme Court is implemented, enforced immediately. And we all saw how the police swung into action and made sure that, Amechi had a hitch-free entry into his office and all that. So, in this regard, one would have expected that Supreme Court haven't taken that decision. The IG, haven't been authorized by the president, should either communicate the states where caretaker committees are being used.
Yes.
Communicate them to do the needful or face prosecution. Yes. And also, it is also a case of character. We saw a particular state, that very day the Supreme Court gave the judgment, a particular state asked their caretaker committee members to resign. They all resigned. That is character and integrity. Holding on to power against the wishes of the law, against the wishes of the people, it's really an aberration.
We'll still come down to holding on to power. But then there has been concerns and arguments around the Supreme Court judgment, because, when we have conversations like this, people tend to, periscope on the judgment and bring out certain things that, they consider a lacuna and make arguments from it. So now let me read it out very briefly. It said, By the same token, by a law of a state house of assembly, the tenure of local government councils can be legally extended, underscore, for any reason, such as insecurity or war, or if it becomes impracticable or impossible for elections into the local government councils to be conducted. Now, on my show yesterday, I also had a legal practitioner who argued that there is a caveat to tenure elongation, and that is in face of insecurity or war. And now he likened it, I now asked questions with regards to the River State situation, and he was the opinion that it is not yet a war situation. Now I asked, the political crisis in River State, can it give rise to insecurity? If you recall, towards the time of very close to the expiration of the tenure of the outgone chairman, still on open conversation, we had conversations with different stakeholders. And some of them, particularly the people there that were in support of caretaker chairman, said that it was impractical to hold elections, local council elections, because the polity is already heated, and if elections are to hold, it was going to be very violent and might cost lives. Now, same people are also now arguing that it wasn't that bad. So now, what do we go with? However, there is also a caveat. He said for any reason. And when he said for any reason, such as he's citing an example of what can qualify as any reason. So as any reason in this circumstance may be subjective. So if the State House of Assembly, in their wisdom, they have analyzed the polity or the situation in the state and say this is dangerous at this point, or for whatever reason they think is legal, extend the tenure. Should they hold? Barrister Ndamsi.
Yes, thank you very much. Going by the provision of the Constitution said in state of insecurity or war, and it went ahead to say if it is impracticable
or impossible
to hold the election. That is to say, in interpreting that section of the Constitution, you will need to consider other ingredients which can make the holding of election at that period impossible. Okay, so what has happened in River State over time, heated up the polity, and it would be very impracticable, impossible to hold local council elections at that time. And I think that is the reason why the State Electoral Commission never brought out a timetable.
It wasn't a case of the RISEC not bringing out a timetable. It was a case of the RISEC coming out to say that they have not been funded by the state government.
Yes, why I said why the RISEC didn't bring out timetable is this. The River State Law Number 5, the River State Local Government Law Number 5 allows the State Independent Electoral Commission to bring out timetable 3 months to the expiration of tenure of local government chairman. And you see, time was fast spent, okay, because of the disagreement between the factions in the state. Time was fast spent, and possibly the government, in their own wisdom, didn't want the election to hold. Otherwise, he would have instructed the RISEC to bring out timetable. So timetable never came out. So the assembly saw the need, saw that it was impracticable, impossible to hold the elections, and did the needful by extending the tenure of local government.
All right.